Yes, Pinto.
Yes,
Sanjay
ma'am.
Pinto.
Police stations constitute the cutting edge of the law enforcement machinery. But when unscrupulous individuals choose shortcuts and attempt to use the police as recovery agents by striking deals with local officials in classic civil disputes, that line between prosecution and persecution gets blurred. There is a clear ban on police stations functioning like kangaroo courts, or what in Tamil we refer to as katta panchayats. On orders from the Madras High Court, a government order GO number 1580 was passed in 2008. Clause 9 of this GO is firm that where the dispute prima facie appears to be of a civil nature, the police should not enter into any inquiry or cause settlements. Mind you, not even conduct an inquiry, much less register an FIR. The first bench of the Madras High Court in G. Anand versus Inspector of Police in 2015 was emphatic that this GO should be followed in letter and in spirit, and added that the objective is not to be an arbiter of civil disputes. The police authorities thus cannot take over the job of civil courts to adjudicate disputes. Now, a sizable chunk of anticipatory bail applications filed under section 438 of the Criminal Procedure Code and quash under 482 CRPC in the country relate to alleged offences of criminal breach of trust and cheating under sections 406 and 420 of the Indian Penal Code. It is debatable as to whether there was adequate application of mind in sniffing out or detecting criminal intent or mens rea and essential ingredients such as entrustment and deception from the inception before registering FIRs. A common thread that runs across these civil disputes is the alleged non-payment of contractual dues or projected balance consideration in property transactions. The Madras High Court in M. Murugan versus M. Senthilvel in 2022 held that if really the balance sale consideration has not been paid by the first petitioner, giving a police complaint or filing a private complaint is not the appropriate remedy. The matter has to be necessarily agitated only before the civil court. Even the Supreme Court in Veer Prakash Sharma versus Anil Kumar Agarwal in 2007 had held that the non-payment or underpayment of the price of goods by itself does not amount to commission of an offence of cheating or criminal breach of trust. In some cases, they add 506 of the IPC to add criminal intimidation to the offence, to the cocktail of offences that are conjured up sometimes in police stations by de facto complainants. Here again, the key factor is that fraudulent intention should have existed at the outset. The Supreme Court in Uma Shankar Gopalika versus State of Bihar 2005 had clarified that if the intention to cheat develops later on, the same cannot amount to the offence of cheating. In monetary cases, criminal prosecution cannot be a quick fix remedy by strategically bypassing the correct route, namely a suit for recovery which entails payment of court fee. In a catenary of cases of decisions by the Supreme Court and our High Courts, the trend of giving criminal colour to civil disputes has been deprecated. The Supreme Court in Mohammad Ibrahim versus State of Bihar 2009 had cast a responsibility on criminal courts to ensure that the proceedings are not used for settling scores or to pressure parties to settle civil disputes. The apex court in Mitesh Kumar Jha versus State of Karnataka 2021 had termed it nothing but an abuse of the process of law which must be discouraged in its entirety. That a criminal trial in such civil disputes would be a punishment was reiterated by the Madras High Court in South India Music Companies Association versus Gemini Auto and Gemini Entertainment Mobile India Services 2022. It would be harassment of the petitioners if they are asked to appear before the court to face a trial when there is absolutely no offence made out, even if the complaint allegations are taken as true. Truth be told, the black and white component in real estate deals leaves parties without sufficient documentation to prove actual dues. This is a reality. And this explains the difference often in the sale price mentioned in an agreement for sale and what is recorded in the sale deed. A sale agreement is a transitory document and the final word ought to rest in the sale deed which records the concluded transaction. That's the disincentive and a risk involved in stamp duty or tax evasion. Khaki cannot be used to purge the sin of black and white.